elevating the discussion while talking about the things that matter most. You're listening to Society and the State, Life, Liberty, and Your Pursuit of Happiness. Now, your hosts, Connor Boyack and Brian Hyde.
Welcome, everybody, to Society and the State. This is episode 70, and today we are joined by Nate Wessler, a staff attorney in the ACLU Speech, Privacy, and Technology Project, to talk about a Supreme Court case that Mr. Wessler here argued before the Supreme Court that we're going to be hearing a lot more about, presumably, here within a few months. So, Nate, thanks for joining us today.
Thanks very much. Happy to talk.
So I know a lot of people perhaps have heard just a tiny bit of this case, maybe in the news. The case we're talking about is Carpenter versus United States. And it's a case, at least as I understand it, that is going to really or potentially transform a lot of what the Supreme Court has said as it pertains to, Fourth Amendment, the right to privacy from decades ago before any of these, cell phones and things existed. So maybe if we could, let's first start out with the facts of the case. What happened to this Carpenter fellow that led to your guys' case now before the Supreme Court?
So this case comes out of Michigan in the federal system. So Mr. Carpenter was alleged to be part of a kind of rotating group of men in Michigan who were ironically robbing cell phone stores. So there was a series of robberies of T-Mobile stores and Radio Shacks, mostly in the Detroit area, one of those robberies in Ohio. These happened over the course of more than a year. And so local police were trying to figure out who might be involved. And at some point, they arrested a few suspects. And one of those suspects pretty quickly flipped and started giving evidence, including the phone numbers of other people who he said were involved in some or all of these robberies. One of those phone numbers was for Mr. Carpenter's phone. And so police then partnered with federal investigators from the FBI and the U.S. Attorney's Office and obtained a court order, so not a search warrant. We can talk about the difference more later, but a court order on a lower standard from a federal judge that let them send a request to Mr. Carpenter's cell phone company asking for 5 months' worth of his historical cell phone location records, charting out where he was over the course of those months. They, of course, wanted that information so they could try to place him near or at the scenes of those robberies at the times of the robberies. And they got those records back, got about 4 months worth of records back from his cell phone company that revealed almost 13,000 individual location points for him over the course of those 4 months. It's about an average of 101 location points per day. So actually a lot of data. And an FBI agent went through those, looking at the days of the robberies, and lo and behold, he was able to place Mr. Carpenter at or near the scenes of those robberies at the relevant times. And when the case then went to trial, that became a key part of the government's evidence against Mr. Carpenter, and they eventually secured a conviction, leading to a kind of unimaginable 116-year sentence, which is partly attributable to the very harsh mandatory minimum laws that are now in the books, which is maybe the topic of a whole nother podcast.
For sure. Yeah. And so really this the topic of this case, though, really, as I understand it, centers around the warrant requirement. And correct me if I'm wrong, you're the attorney here. The warrant pertains to where a person has a reasonable expectation of privacy. And so if this individual, if Mr. Carpenter had sensitive documents or intimate photos or bank records stored on his phone, the position of the government would likely concede that they would have to obtain a warrant to access that information. A warrant, of course, requiring a higher standard of evidence, which requires the government to prove a little bit more about their suspicions about Mr. Carpenter in this example of being the individual who they suspect as having committed the crime. So they have to prove a little bit more than with this the court order. Is that fair to say? It really boils down to the amount of evidence or the probability of their suspicion of the crime?
Yeah, that's right. The warrant procedure is the gold standard under the Fourth Amendment. That's what's spelled out in the Fourth Amendment itself. The framers of the Bill of Rights explained that in order to conduct the kind of search that requires a warrant, you have to go to an independent magistrate judge, demonstrate probable cause, which means real basis, real evidence to suggest that the target of your investigation was involved in the crime, and you have to particularly limit the things you're asking for to the scope of your probable cause. And that's also, so the probable cause showing, that's important, as you were saying, but that particularity requirement is also important. And you can start to see why in these cases involving cell phone location records. The police, at the time police requested Mr. Carpenter's records, there were, I think, 4 or 5 robberies that had happened already that they were trying to place him at. And those were on particular days. They knew what days and what times those robberies happened on. But instead of just asking for 4 or 5 days worth of records scattered across those months, they asked for a whole uninterrupted 5-month block of his information. They got 127 days of data, which is, a very broad request, and the kind of thing that if they'd gone through the warrant procedure, a magistrate judge very likely would have said, well, hold on a minute, let's scale this back. I'm going to give you just the evidence that's actually tied to these crimes, not, a 4-month diary of everywhere this person has gone and everything he's done.
And so if the data that they were seeking was on his cell phone, the government would likely concede they would have to do it. It would have to be particularized. It would have to have probable cause. They would have to be able to show that they needed that cell phone, to decrypt it, access it, and get the data. But the central problem here, again, as I understand this issue in the Carpenter case, is not when people store data on their cell phones. Of course, this you mentioned that with Mr. Carpenter, the cell phone company had all of the location points that they were able to have, and that's because these were stored on servers outside of Mr. Carpenter's phone. When you are sending text, when you're sending email, all of these things are being sent into what's called the cloud. They are hosted on, Verizon servers or Apple servers or whoever. And so the question that this boils down to, correct me if I'm wrong here, and then I'd love your thoughts on it, is do I, Connor Boyack, or Mr. Carpenter, do we have a reasonable expectation of privacy in the data that we have transmitted to another person's server, Verizon server, AT&T server? Do we have an expectation of privacy in that data? Because if not, then the government can more easily access all of this data that reveals a lot about ourselves. As you point out, 101 points of data for Mr. Carpenter every single day. You can tell a lot about a person based on where they're going and how often and when. So do they have that reasonable expectation of privacy, or do we not? Is that a fair description? And if so, what are your thoughts about that?
That's exactly the key issue in this case. This case is important for 2 reasons. One is, as you were just saying, location data is really sensitive. It can chart out what we do, who we spend time with, whether we spend the night at home or at a lover's house, if we stop off at a liquor store or an AA meeting. You can, it's hard not to be able to find some highly sensitive, private, maybe embarrassing part of someone's life that couldn't be revealed by this data. So that's the kind of underlying reason. But the doctrinal kind of Fourth Amendment heart of this case is exactly that, this question of whether we in modern society are going to be considered to have given up all of our Fourth Amendment rights and our privacy interests anytime we engage with a company that has access to sensitive information about us. The legal doctrine that we're arguing over here in this case is often called the third-party doctrine. And it comes from a pair of cases in the 1970s that said, the first of them said, well, when a person is doing business with their bank, that bank is, in this kind of legal terminology, known as the third party. If they are sending canceled checks to the bank, or if there are deposit slips with the bank or account statements, those are the bank's records. Those are based on information that the person has voluntarily shared with the bank in order to transact business. And the person should know that they've given up their privacy interest in that information by sharing it with the bank. And so if police go to the bank, too bad for you. They don't need a warrant. You have no Fourth Amendment rights there. There was a follow-up case later in the 1970s about dialed telephone numbers, saying that when a person dials a number to connect a call, they're voluntarily sharing that number with the phone company. And if police want to go to the phone company and get a record of everyone you've called, so be it. Too bad for you. Under the Fourth Amendment, those are not your records and you can't complain. Now, those decisions were heavily criticized in the 1970s, and they were very split decisions by the Supreme Court. But whatever we think about, what the wisdom was of dealing with those kind of pre-digital paper records 40 years ago, this doctrine has not held up well in the intervening 4 decades. And today, when we live in a world where it is really impossible to be a full human being without having huge troves of highly sensitive private personal data held in the cloud or on the servers of companies we do business with. So we're talking not just about these location records from our cell phone company or held by Google, for that matter, if you have an Android phone or use Google Maps. We're talking about things like the contents of our emails and our text messages held by Google or Yahoo or AT&T, medical records, other information about the state of our bodies, heart rate data from a smartwatch, or information about fertility that people might use with apps on their phones. You can think about information about finances and personal relationships. I mean, there's no end to what we now store elsewhere that in pre-digital time we would have had on us, right? It would have been in our date book or our diary or our locked filing cabinet at home. And so the core of this case is to make sure that the Supreme Court can help us understand that these changes in technology aren't going to totally pull the rug out from under our Fourth Amendment protections, that the fact that now a pervasive location record showing everywhere we went over the course of years isn't just an open book for law enforcement, but rather that they have to go to a judge and get a warrant because we really do still have a privacy interest in that information.
Nathan, was there a lot of dissent between the Supreme Court justices as they were hearing the arguments in Carpenter versus the U.S. As far as whether this technology was opening the door to uncharted territory? I mean, does the Supreme Court typically, have they sided more in favor of privacy, or have they more been in favor of, hey, we got to give the police the tools they need, to do their job?
Yeah, so this is really the third in a series of cases from the last few years involving how to interpret the Fourth Amendment in the digital age. The first case from 2012 was called United States versus Jones, and that was about when police put a GPS tracker on someone's car and then use it to surreptitiously track that car over the course of weeks. And in that case, unanimously, all 9 justices agreed that that's a search under the Fourth Amendment. That even though there are older cases that say, too bad for you if police are tailing you while you're driving around and recording a record of everywhere you're going, this is a new technology that provides just unprecedented capabilities, which should be regulated by the Fourth Amendment. In another case a few years later called Reilly versus California, the Supreme Court again unanimously held that even after police have lawfully arrested someone and seized their phone during that arrest, police need to go get a search warrant from a judge before searching the phone, which was a departure from older cases in the pre-digital age, talking about how you can search regular analog objects like a cigarette pack, for example, on a person's body after being arrested without a warrant. So there's a strong trend of the court towards reaffirming the application of Fourth Amendment protections in the digital age. At the oral argument in the Carpenter case, it was another really fascinating and I think powerful example of how this issue cuts across the kind of traditional ideological lines.
Yeah.
Right. So you had Justice Roberts asking very skeptical government questions of the government about why the court shouldn't find this location information to be private and protectable. Justice Gorsuch really pushing the government's attorney about how we could think about protecting these records as a property right of people. Right. That these are the kind of records that normally pre-digital age we might have had, in our own physical custody, and today they're held by the phone company, but actually protected by strict federal privacy laws, which may give a privacy and a property interest. And then you had justices like Justice Sotomayor and Justice Kagan expressing, deep concern about the privacy interests. So it's always a little dangerous to try to predict where the court will come down before they issue a decision, but it seems like there is still pretty significant momentum from across the spectrum on the court towards making sure the Fourth Amendment stays relevant.
Now, if they don't, if they decide in a way that favors the government and allows easier law enforcement access to, this type of information held in the cloud or held on other people's servers. We've talked about a little bit around the edges as we've been discussing other things, but if you'll answer this head on, what are the implications if the Supreme Court sides with the government in this case? For our listeners, for the average American, what are the implications in a ruling that favors the government?
It would be really, really devastating if the court were to just hold that those 1970s cases should apply just completely and rotely to any other kind of record that is held by a third party today. That's going to open the door to tremendous violations of privacy. I was talking earlier about some examples of the kinds of really sensitive records that are now held by companies we have relationships with. It's not only the kind of medical or health data I was talking about, but lots of information about the interior of our homes that is really shockingly detailed. So as we're moving into the age of smart technology and the so-called Internet of Things, people are increasingly using things like smart thermostats that can automatically detect when a person comes home or when they're leaving, and sometimes even which room they're in. Smart meters that electricity companies are deploying collect and transmit such a granular accounting of electricity use that researchers actually have been able to sometimes tell which television shows a person is watching because of the minute fluctuations in electricity usage based on which pixels are firing on the TV.
Wow.
Our refrigerators that are now automatically placing orders to refill our supply of milk and bacon. You can tell what a person's eating, right? Not all of this stuff, and probably most of the stuff isn't going to be incriminating in this kind of traditional sense, but it's deeply private. And it's the kind of deeply private stuff that we've always expected the Constitution to protect. And so, a ruling that said, digital is unprotected, essentially, would really start to undermine the bedrock of the Fourth Amendment in modern society.
So I have another quick example to offer, and then a final question for you. So here in Utah, and working with our affiliate, our state-based affiliate of the ACLU, they actually litigated a case dealing with the controlled substance database in our state. I think this is the case in many states, right, where the government requires your sensitive medical information about medications that you're taking be placed in this database. The argument is that they can therefore more easily track abuses, especially with the opiate crisis. And so they collect all this information. It's mandatory. You're not able to opt out. And so your sensitive information about pharmaceuticals you're taking, antidepressants, whatever is in this database. And here in our home state, there was a case where law enforcement went on a fishing expedition and they found all sorts of stuff about all sorts of people. They didn't have to go for a judge. There was no probable cause. There was no particularity to a specific individual. There's been abuses in all sorts of other databases like this. Driver's license, right, where a cop goes in and is looking at an ex-girlfriend or whatever. And so it's amazing to me, it's astounding the amount of information that we have either voluntarily that we're transacting with, Verizon or Google or Apple or whatever, and we're just using the phone and not really consciously realizing that we're quote unquote consenting to share this sensitive information with another company. We're just using it, right? We're sharing it with the person to whom we're texting, but we don't realize that, in so doing, we're kind of inviting a third party into our intimate conversation or intimate life. So it's not just location information, which is the importance, I think, of this case that you argued before the Supreme Court, that certainly location information is extremely revealing and for most people would be considered deeply private, as you point out. But the amount of data we have about ourselves increasingly, as you point out, with the Internet of Things coming on board and smart homes, it's mind-boggling the amount of data about ourselves that we either generate directly ourselves or is being generated by us merely using these devices or living or installing a device and then setting it and forgetting it. So the implications of this case are, I think, quite profound. I do want to ask you, though, a little bit different of a final question that touches on this case but goes a little bit more broadly. As we've worked on a number of issues, both dealing with surveillance and privacy and controlled substance database, but others as well, partnering here with our ACLU affiliate, working on these issues, the message has been, and the message of your case is, get a warrant. Develop probable cause, have that particularity, go before a judge and make your case. Increasingly, however, we found a lot of criticism from people, including ourselves in many cases, where it is considered that warrant requirement itself is fairly easy. We kind of idealize this notion of having, a judicial check and balance and get a warrant. The judge will, make sure that only those appropriate requests are being authorized and that law enforcement is being held responsible and not going too broad, et cetera, et cetera. In your perspective, in your experience, do you feel that the warrant requirement is kind of the gold standard and is adequate, or is this just like a minimum level that we're saying, like from due process at a very minimum get a warrant, but maybe it itself is not this amazing check and balance? Do you have any thoughts about that issue?
Yeah, it's a really great question. So, when the framers of the Fourth Amendment were putting together this warrant standard, they were trying to strike a balance between the need of law enforcement to do its job and the need of the people to be protected against overreach. And so they tried to put some friction into the system by imposing this probable cause requirement and the requirement to go to a judge. And that, for most kinds of investigations, that works pretty well. But there are I agree. There are certain, types of data, particularly really new types of data in the digital age, that maybe are so invasive, so private, that we should be thinking carefully about whether they should be walled off at all. And it's not unprecedented to protect certain data even from law enforcement investigations. The IRS, for example, has very stringent privacy protections to encourage, candid reporting of taxes, but to protect people from other government agencies getting into it. Mm-hmm. There are federal regulations protecting drug abuse treatment records from law enforcement access in most situations, so to incentivize people to be able to, be candid with a drug treatment facility about whether they have an addiction problem and then try to get treatment without being at risk of being prosecuted for that admission that they had been abusing drugs. So I think that is a really fair question. And, there you can easily imagine things like, for example, pacemaker data, right? A device implanted into our bodies to keep us alive that also, has now in the digital age, the ability to record a lot of information about the state of our bodies. There's older Supreme Court case law saying that, some surgical interventions into the body are not allowed even with a warrant because they're so invasive and maybe so dangerous. Maybe we should start to apply that standard to some of these particularly invasive types of data. So that's one part of the consideration. But the other part is we should be thinking as a society about what we actually want to be storing and keeping. And that should be, something that government entities think about. The prescription monitoring database, Utah's controlled substance database, is a great example. To think about how many years into the past is it really necessary to keep those records? Because if they exist, at the end of the day, they will be vulnerable to search at some point. Yep. And then we should be talking to, pressuring the companies we do business with to also limit what they keep, right? Is it really necessary for Google to have 10 years worth of our location history, or for AT&T to have, 5 years worth of our cell phone location data? Or should they be keeping less, which, could balance their business needs with our privacy concerns?
Nathan, one final question for you. Obviously, a lot of this is going to be hashed out within the courts. What kind of personal responsibility should we as American citizens be looking at exercising? I mean, some people may want to avail themselves of encryption for their content, but as far as the decision to have a cell phone, what companies to go with, is there anything we can do in terms of assuming more personal responsibility in exercising that right to privacy?
Yeah, well, I think maybe the best thing, the most important thing people can do is speak out to elected representatives, right? So the courts are one vitally important and crucial way to address these issues. But state legislatures and members of the U.S. Congress are also a really important outlet. And Utah actually has one of the strongest laws in the nation protecting cell phone location data. In 2014, the Utah legislature passed a very strong law requiring a warrant for historical cell phone location data and real-time cell phone location tracking, which is great. And we should see more states doing that, and we should see people in Utah pressing for the same kinds of protections for other kinds of sensitive data. That's not enough at the state level, though, because federal investigators aren't necessarily bound by state laws, and so we need to also pressure Congress to update the law. The law around cell phone records and other similar digital records dates to 1986 and is far lagging behind modern technology. So there's a lot of room for improvement there. And then in terms of our personal uses of data and electronics, everyone has to draw their own lines where they're comfortable or not. There's some stuff that is just unavoidable, though. So in order to use a cell phone as a phone and as a communications device, it has to talk to the cell phone company. And that means it's impossible to avoid the collection of that kind of location data. So, there are a small number of people who are going to be willing to just not use a cell phone and rely on landlines and other methods. And that's great if that works for you. But we shouldn't have to give up our privacy in order to be full participants in modern society. And that's why the law is so important.
Even as you pointed out, in old Supreme Court precedent with landlines, there are these cases saying that you don't necessarily have privacy because the numbers that you're dialing is even metadata with a landline is being taken, right? So it's not like
that's absolutely right.
There's no utopia. We keep saying final question. This one is extremely brief, Nate, and then we'll conclude here. This great episode is when can we expect? When should our listeners be watching for a ruling in the Carpenter case?
The Supreme Court will decide the case by the end of June at the latest. That's the end of its current term. It's possible it could come a month or two before that, but hard to know. So we'll be watching over the next few months.
As will we. Deeply appreciate your involvement in this case and pushing it forward to the Supreme Court and protecting our privacy in an increasing digital age. So Nate Wessler, we're going to be linking some information to our show notes page, societyandthestate.com/70. And thanks again for joining us today.
You've been listening to Society and the State. For show notes, archives, and more great content, visit societyandthestate.com.